Critics of third-party litigation financing have broadly advocated for discovery rules that would allow litigants to learn whether their opponents were receiving funding from a third party, as well as the terms of such financing agreements. But the rules of discovery are premised on the idea that discoverable evidence is relevant evidence. And there is yet another judicial decision asserting that facts about how a party funds its litigation are not relevant to the underlying dispute. In Space Data Corp. v. Google LLC, 5-16 CV 03260, the United States District Court for the Northern District of California denied a defense motion to compel discovery as to potential litigation funding arrangements that might have been considered by the plaintiff, Space Data. That case arose from negotiations between Space Data and Google over how Space Data might contribute to Google's Project Loon, an internet beaming balloon initiative. Space Data alleged that Google unlawfully used confidential information and trade secrets disclosed during their partnership discussion in 2007 and claimed that Google and its patent subsidiary, Alphabet, infringed 3 of Space Data's U.S. patents. Google sought discovery of the minutes of Space Data's board meetings that involved the discussion of potential funding for the suit against Google. Google also sought to depose a member of the Space Data board about the potential funding. When Space Data refused to provide the minutes and when the board member refused to answer deposition questions about litigation funding, Google filed a motion to compel. The district court denied the motion to compel because the defendants failed to establish how the requested materials were relevant to any party's claim or proportional to the needs of the case. Although Space Data proffered that it did not have any third-party litigation financing in this case, the court went further and suggested that even if litigation funding were relevant, potential litigation funding is a side issue at best. The court also concluded that there is much discovery that would be more important in resolving the merits of this case. And the burden of responding would outweigh its likely benefit to defendants. To be sure, Google's motion to compel was a reach. It is hard to understand how any unrealized ideas about litigation funding could be relevant in any dispute. But the district court's decision did more than just confirm an intuitively obvious proposition. It also pointed out that, in considering the discovery of any matter related to litigation funding, courts will assess the relative benefits and burdens of the discovery as well as the relevance of the material to be discovered. In this connection, the disclosure of funding arrangements is always going to impose a heavy burden on the producing party, hampering its ability to exercise strategic options. Attorneys who face a motion to compel the discovery of material related to third-party financing would do well to keep this consideration in mind.